All right, we're just going to go for it. All right, good. All right. Thank you. Welcome to the Village of Corrales work study. This is going to be a virtual meeting. I'm going to call this meeting to order, and I guess we're going to do the pledge. We're going to be very patriotic tonight and do the Pledge of Allegiance 3 times. So I'm going to call the meeting to order, and we're going to stand and do the Pledge of Allegiance. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you, everyone. All right, let's make sure we didn't lose any counselors. Counselor Waldman. Counselor Wald. Well, let's go to Counselor Murray.
Yes.
Counselor Burkett. Counselor Lucero.
Here.
Counselor Knight.
Here.
Counselor Parker.
Here.
Counselor Burkett. Counselor Waldman. Melanie, would you check in with them just to see if they're having any, oh, there's Zach. Thank you. Counselor Burkett. He's connecting. Counselor Burkett. Thank you. Counselor Waldman. Melanie, would you just check and see if he's having any trouble getting on? And in the meantime, we will go ahead on to our agenda item for this meeting.
He's joining now, Mayor.
Thank you. Counselor Waldman? Well, we'll wait till he connects to audio and then he can tell us he's here. Tonight we have with us Randy Van Vleck, years of experience with the Municipal League, and he's going to do a presentation and discussion of the duties and responsibilities of public officials. We realized with the pandemic and new people, et cetera, just seemed like a good time to do a little bit of an overview of those things. And he understands that he probably doesn't have all the time in the world. And he also, I think, has another appointment. So without further ado, go ahead, Randy.
Well, let's make sure we're all on the same topic. Do you want to hear about the duties and responsibilities, or do you want to hear more about the Open Meetings Act? I guess I need some clarification. I got some mixed messages over the last few days.
Okay, well, I think
either one I'm prepared to do.
Okay, I guess I thought that was what was going to happen with the Open Meetings Act and maybe duties and responsibilities. So just start. I think the Open Meetings Act is what we're, is the place that we can most get into difficulties. So
yeah, because I mean, I think we can make this into kind of a series of sorts, if you wish. And
okay.
So let's just. Can someone make me a co-host? I have a slideshow that I put together. I can kind of show it as we go along.
Okay, Melanie, can you make him a co-host for us?
If not, that's fine. I can.
You should be able to share your screen now.
Okay, good. Let's do this. Share.
Thank you.
Okay. Okay. I guess I'm sure. Am I sharing my screen? Can you see my Open Meetings presentation?
We can see it.
Okay, perfect. So let's start talking. We'll start with the basic idea about what the public policy is. The public policy is pretty clearly stated, by the state of New Mexico and by the legislature that the conduct of public meetings or meetings by public bodies should be conducted in the open, should be transparent as possible. We should always strive for openness in what we do. Let me see, what did I just do there? And so, God dang it, I don't want to do that. Okay, so how do I get out of slideshow mode now? There we go. I'm sorry, folks. There we go. So when public bodies meet to formulate public policy, to discuss the public business, or for the purpose of taking any action, the legislature has essentially declared that those meetings should be open to the public. Now, that means that means a couple of things. The first thing it means is that the public body needs to give notice of its meetings, because without proper notice to the public, those meetings can be held secretively. So the first and foremost, and that falls primarily to the city clerk, the village clerk, is making sure that reasonable notice is given of the meetings that they're going to have, and that applies to meetings whether they're open or closed meetings. So yeah, I know you just got done having an open meeting and a closed meeting. So both of those are at least subject to reasonable notice. Now, the good thing about the reasonable notice requirement is that you, as the public body, are the ones who decide what that reasonable notice is. Now, there are certain parameters that you have to fall within that are established by the legislature and by opinions of the Attorney General. But generally speaking, you can set your own reasonable notice requirements. And you do that annually by virtue of passing what's probably familiar to you all now is an open meetings resolution. So you pass this resolution and declare, among other things, what your reasonable notice is going to be for your meetings. One of the things that you have to do in conjunction with giving notice that the meeting is going to take place is give notice what you're going to talk about, and that takes the form of an agenda. And so every time you give a meeting notice, every time you publish a meeting notice or post a meeting notice, it needs to either do one of two things. It either needs to include an agenda, so you can post an agenda along with your meeting notice, or it needs to advise the public how they can obtain a copy of the agenda. Now that agenda needs to be a very specific document. Now, once upon a time, you could rely on the old Robert's Rules of Order and just say new business, unfinished business, things like that. We can't do that anymore. And so we have to include in that agenda a list of the specific items of business that we're going to discuss, or transact, vote upon during that meeting. And so that it's really important that agenda be put together carefully so that things aren't omitted, because while things can be removed from an agenda, things cannot be added to an agenda. Your agenda must be finalized and formalized, almost in stone, 72 hours prior to the meeting. And so that's 3 days notice. And so
Mr. Van Vleck, this is Councilor Murray. May I ask a question?
Sure, absolutely.
All right, so you're saying that the meeting has to be set in stone, but can discussion items be added at the beginning?
Well, here's the problem with that. People don't look kindly upon it. People look upon that as being a little disingenuous. And here's why: because they've been given notice that the meeting is going to talk about A, B, and C. And if you add D, E, and F, then they would have no idea in advance that that's coming. And so although legally you can do that, I don't think it's a good practice, because you get a reputation for doing that. You get a reputation for, at least in the public's eyes, trying to hide the ball from what you're trying to do. So, I mean, there's ways of getting things on an agenda in advance so that you can make sure that it gets its proper treatment. But I would not make a common practice of adding things at the beginning of a meeting, even if it's for discussion only. It's just.
But if those items are to be added, it has to come before the 72 hours. Is that correct?
Yeah, I mean, that's the best. That's what the law says. I mean, if the law says essentially it's got to be set in stone, 72 hours if you're gonna act on it. Again, that's what the law says. You can talk. You can certainly add things to discuss, but I think the better practice is to, at the beginning of the meeting, maybe add something to vote upon to put on the next meeting. And so that now the public knows, okay, this item that, a counselor or somebody wants is going to be fully discussed, openly discussed at the next meeting. I think that's just the better practice.
Okay, another question then. Say at the end of the meeting, can a motion be made to set a new meeting, say for a special meeting or anything like that? in the
Well,
future.
Yeah, I mean, I think those are the types of motions, those are more, and even though the Open Meetings Act doesn't distinguish between, this type of action items and parliamentary motions, I think there's an inferred distinction between those kind of motions. Otherwise, you'd never been able to do an amended motion, or never be able to call the question, or never be able to do any of those parliamentary things. So I think those types of procedural motions are acceptable. So for example, if you wanted something on an agenda, at the next meeting, and you couldn't go about it, or didn't want to go about it through informal mechanisms, you could certainly make a motion to put something on the agenda for the next meeting. I don't think that is a violation of the Open Meetings Act.
Yeah, thank you. I'm sorry.
No, that's fine. That's I want to make sure your questions get answered. And so this agenda requirement is very important, and people watch these things. People watch your agendas. People watch to see that you stay on your agenda and don't add things at the last minute. So this is very important to remember. One of the other things that the Open Meetings Act requires is that you keep minutes of your meetings, and at a minimum, the minutes need to record the time, the date, the place of the meeting, who was at the meeting, who wasn't there, a brief discussion of what was discussed, or what those proposals were that you talked about, and then a record of any decisions that you made, including how each member voted. And so that, to me, that's kind of a cue. And I don't know how you do it. I haven't been to a Corrales meeting for a long time, but that kind of cues me into the idea that, most of your votes, I think, should be roll call votes, simply because it makes certain that this requirement is complied with. It doesn't take a lot of extra time, and that way everybody's on record, and there's no mistakes later on, or more confusion later on as to how one member voted or how another member voted.
Randy?
Yes.
I think we can make arrangements for you to attend as many meetings as you want. Corrales, so.
Okay, well, that's fine. I'm not mugging, and bugging for invitation, but if you want me there, I'm happy to be there. I know Mr. Audio is on the line or on the call too. Probably more capable than I, but you can have any one of us anytime, I think.
Now, is the public able to speak in this?
Mayor?
No, this is a work study meeting, so the public is, of course, welcome to attend per the Open Meetings Act, but it's to listen and not necessarily to participate. Thank
Okay,
you.
I would invite Mr. Randall to the next meeting then.
Well, thank you. Go ahead,
I-
Randy.
I would
Okay.
hope he would be there. Thank you.
Okay, thank you. So what that means for us is that there's no secret ballots. Even when we go into closed session, we're going to talk about that in just a couple minutes of what that means. All the votes take place in a public meeting. And so we need to be, and I think, everybody's pretty clear on that, and we all understand that. Minutes, on the other hand, are public record. So once minutes are prepared, they're available for public inspection and for public scrutiny. Draft minutes need to be prepared within 10 days, 10 working days of the meeting. And the governing body is supposed to act upon those minutes by the next meeting of the quorum of the body. But one of the things that I want to talk real quickly about. Well, I got two more things to talk about. Then we'll talk about closed meetings. There some additional considerations under the Open Meetings Act, and I think that's part and parcel of what we're doing right now. It never used to allow for telephone conferences until about 5 or 6, maybe 8 years ago, and so people had to be at the meeting to conduct business. Now we recognize that people can't be there. We recognize that technology has improved, platforms like this, and so assuming that there is some additional authorization somewhere, telephone participation is permitted. I know the village has passed as part of their ordinances a provision that says just this, that if it's inconvenience, if it's difficult or impossible to attend a meeting, that members of the governing body can attend by telephone or by Zoom or things like that. So that's what makes this type of a meeting legal. All participants, however, on that Zoom call or on that telephone call must be able to hear and to be heard. And so Zoom is a perfect platform for that, because it allows that kind of activity to happen. One of the things I want to cover, which really isn't covered in the Open Meetings Act, but has been the product of case law and jurisprudence over the years, is the notion of what it really means to have an open meeting, and what it means when they talk about a quorum of a governing body. The Open Meetings Act says a quorum of a policy-making body. Whenever there's a quorum of a policy-making body together at a meeting, then that meeting has to be public. And the language they use is that let me go back here. It says, I'll go back to this slide. It says all meetings of a quorum of members of any board, commission, et cetera, which includes us, are deemed to be open to the public. Now, to the English majors and school teachers in this group, that may mean one thing, and to others it means another thing. But what it means to the Attorney General is this: it really means any meeting of a quorum or any series of meetings where the membership of the meeting adds up to a quorum have to be open. And this is the so-called rolling quorum or walking quorum as some people call it. And what that means is essentially you can't break up into small groups, talk about things off-site, and then come back to the meeting and then have it come back to your regular meeting, in 2 or 3 days. I used to call it playing the part of Noah, because I would march my counselors in 2 by 2 to talk about things, because 2 people in the village of Corrales is not a quorum. And so, if 2 people have a meeting, that's fine. And it's not subject to the Open Meetings Act. But as soon as we include a 3rd person in a subsequent meeting, then it becomes a problem, because now you've had 3 people talk outside of a public meeting on a subject that should be relevant and should be the product of an open meeting. And so this idea of this kind of serial meetings where the membership of the meetings add up to 3 in our case becomes a problem. So we have to be very mindful that we don't break up into groups, talk like that, talk in small groups when we otherwise should be meeting in public.
I have a question, Mr. Van Fleck.
Yes.
Yes, go ahead, Mr. Murray.
All right, thank you, Councilor Mayor. But my understanding of a quorum is it's more than 50%. That would be 4 out of the 6 possible counselors. Is that correct?
Okay, you have 6 counselors. Okay, I miscounted. So yes, when 3 members is not a quorum, the 4th member is. So
Okay, thank you.
yeah, so yeah, it's just one more for you, because you have the 2 additional counselors.
Randy, could you talk a little bit though about the difficulties with like rolling quorums or emails, or kind of
Yeah.
add-ons, and how you can get into some difficulties there?
Absolutely. I mean, that doesn't just mean 3 people getting together and talking and then adding a 4th person in a conversation later. That means email communication, text message communications, verbal communications over the telephone. All of those types of communications, when you think about it, essentially circumvent the spirit of the Open Meetings Act. So the Open Meetings Act is really designed for government activities to be conducted in the open, and any kind of subterfuge or activities that tend to undermine that basic understanding that we're going to conduct our business openly and transparently is frowned upon by the Attorney General and other enforcement agencies. So yes, I mean, you can get in just as much trouble if 3 or 4 of you start text messaging back and forth on the same issue as you could if you actually met at a restaurant or someplace like that to discuss these issues. So be mindful of that, and it can happen. It can happen innocently as well. You know, you can have a meeting with 2 or 3 people talking, and then the next thing you know, one of those 3 people talk to a fourth, and you violated the act. And so you just be mindful when you're having individual meetings amongst yourselves that you don't go beyond the 3 people, because that's a clear that's a now clear violation of the Open Meetings Act, you know, according to most sources. And so is that clear? I know it's a little, I know it's sometimes that concept is a little unclear, and it really prohibits any kind of communications outside of an open meeting when that number of participants reaches 4 in your case.
Okay.
Okay.
Don't say anything. Go ahead.
Just a couple of things. I'm going to talk about closed meetings for a couple of meetings. There's 2 ways to close a meeting. The first is where you close a meeting when you're in an open meeting, and that simply requires a motion of a member of the council to close the meeting. They need to state the specific authority for closing the meeting, which we'll get to in just a second. That topic has to be stated with reasonable specificity. So the motion's got to be reasonably specific. You can't just parrot the exception that I'm going to go over. And then the council has to vote on it openly. And if the sufficient people vote to go into closed session, then you can recess into closed session. When you come out of closed session, the minutes need to specifically identify and specifically state that only the specified matters were discussed. So it's kind of a safeguard to make sure, you know, kind of hold you accountable, to make sure that you only go into closed session to discuss those issues that you're legally entitled to discuss in closed session. The second is that you can call a standalone closed session. And when I was a city attorney, we used to do this quite frequently. When we had things to discuss, because we didn't want to disrupt the flow of the meeting. We didn't want to either kick the audience out or have the council move to a back room. So what we would do, we would call a standalone closed meeting for an hour before the regular meeting. Take care of the closed meeting business there, and then go into the regular meeting, and then finish your regular meeting as it normally would be. The procedure for doing that is just the same as the procedure for calling any other meeting. You know, you give prior public notice, but the prior public notice says this is a closed meeting. You state the specific law that authorizes you to go into closed session. The same thing. The topic, the agenda item, if you will, has to be outlined with reasonable specificity. And then the minutes of the next meeting after that must reflect that only those items discussed were only those items that were on the agenda and part of the notice of closed meeting were discussed. So there's two basic ways to go into that closed meeting. So I want to go real quickly before I have to sign off, and go through. There's about 8 exceptions that apply to local governments. So 8 exceptions to this open meetings law, if you will. The first is meetings pertaining to the issuance of a license. So if you issue, renew, suspend, revoke a license, once you can have those meetings, those deliberations in closed session. So in other words, you might have a discussion about a liquor license, and then you have the option under 10-15-1 H1, which is up there, to go into closed session to discuss that. And I'll probably repeat this 8 different times, but all final actions have to be taken in public, in an open part of that meeting. So you got license suspension. So these are licenses that you issue. So Village of Corrales may issue several types of business licenses, liquor licenses, restaurant licenses, things like that. That's what this is regarding. The second exception has to do with personnel matters. And as the title shows, it's limited personnel matters. So this means the hiring, promotion, demotion, the dismissal, assignment, resignation, investigation, consideration of complaints, those types of very specific issues when it pertains to a specific public employee. So when you have those types of issues and you want to discuss what to do with this specific public employee, you can retire into closed session to discuss what to do about them. Now, this is just a deliberative process. What we can't be confused about is any type of hearing. It can be closed, but if the person wants it, if the person being disciplined wants an open hearing, it's absolutely up to them to have an open hearing, and they can have an open hearing. And then finally, any type of action, any type of decision has to be announced, has to be voted on and announced in an open session. The third exception is a very specific exception, and it deals with administrative adjudicatory proceedings. So a good example are your zoning matters. When you have a zone change or a variance request, that's an administrative adjudicatory proceeding. And so that proceeding is going to be adversarial. It's going to be open to the public. Public is going to be permitted to participate in those types of things. And then at the end of the evidence and the end of the testimony, the body is permitted to go into closed session to discuss what to do about that variance request or that zone change request. And the reason for that, I think, is because they're required to come up with findings of fact and conclusions of law based upon the record that support the decision that they're making. So it's a kind of an intensive process, and it's a process that requires some time and effort, and that's why oftentimes governing bodies go into closed session to deliberate these types of issues. The next example, or the next exception, deals very specifically with bargaining strategy for collective bargaining. And do we have unions in the village? No, we don't have unions in the village. So this doesn't apply to you.
Yeah.
If you have had unions, it would be any type of discussion preliminary to those bargaining sessions that you would have, those management meetings, if you will, to discuss what strategy to approach could be in closed session. Fifth example, or fifth idea or topic, if you will, where you can go into closed session is where the council is discussing whether or not to make a purchase from a sole source where that purchase amount exceeds $2,500. And so this, again, another very specific exception. There are specific rules dealing with sole source transactions. And so first of all, you have to meet the statutory definition of what a sole source transaction is under the procurement code. If the transaction you're trying to make meets those criteria and exceeds $2,500, the body can go into closed session to discuss the wisdom of making that purchase. Any decision, once again, the actual purchase of the item or final action on that issue has to be done, once again, in an open session. The sixth exception, if you will, deals with meetings between the village and its attorneys. So meetings which are subject to the attorney-client privilege, which deal with pending or threatened litigation in which the body may be a party, are subject to closed session. So this means one of two things. I mean, either the attorney's got to be there, or you got to be discussing some sort of correspondence or some sort of message that you've received from your attorney in order to make it subject to the attorney-client privilege, number one. Number two, the subject matter's got to be either a pending lawsuit or something where you have a credible threat of litigation against you. And a lot of times municipalities want to try to be secretive about this particular thing. And so let's say that there's a pending litigation. A lot of times municipalities are reluctant to name the litigation that's involved. And I think that's kind of a mistake because the litigation's out there. It's already public information. There should be no reason to keep that information out of your public notice or out of your motion to go into closed session. Pending litigation is a little bit different. I mean, pending litigation where the village might be the plaintiff and might be the person bringing the lawsuit. I think it may be a little more important to keep that the name of the party that you're talking about suing or thinking about suing quiet for a while until you at least get through this meeting and at least get through discussing whether or not and to what extent you're going to take action. The other thing that's confusing about this is that the discussion or the announcement may not come following this meeting. So, and here's the reason. If you have a meeting subject to the attorney-client privilege and you're talking about pursuing a settlement or pursuing a possible range of settlements, and you go into closed session with your attorney and you come to a consensus or an agreement that you're going to offer anywhere between 100,000 to 200,000, that's going to be between the attorney and the client. And you're not going to come out and announce right away, out in public, that we came to an agreement to settle between 100 and 200, because you know what that means. Your lower number is going to be 200. And so I think meetings where the end result is to direct the attorney to do something, that vote doesn't have to be held in public, because that's something that will be revealed later when the action actually takes place. If this is a product of a meeting and you've come to a settlement and you're agreeing upon a settlement after this type of a closed session, then that portion of that meeting, that announcement needs to be made in open session following a vote, because that's going to be the final culmination of whatever litigation is involved. So there's a fine kind of line that we need to split here with respect to what happens at the close of a meeting dealing with attorney-client privilege, because even when you come out of that meeting, that privilege still remains, and you're still entitled to invoke that privilege. And so every time a discussion of this nature takes place, there's not going to necessarily be an announcement to the public as to what happened in that closed session, for obvious reasons. The next exception deals with the purchase or acquisition of real estate or water rights, and for the same reason that letting the information out too soon has negative effects on the village's ability to do business in a very meaningful way. It allows for the discussion of whether or not to purchase real estate, whether or not to purchase water rights to be done in closed session. Once again, any actual acquisition or disposal has to be voted on and announced in an open meeting. So those are the exceptions. I mean, this has been a really very 30,000-foot view of this topic. There are some consequences for violating the act. If you violate the act, there's two things that can happen. One, the actions taken in violation of the act are deemed to be invalid. And so that could mean a variety of things. That may mean you may have to go and do it over again, repeat the action. It may put you in a position where the ability to redo the action is compromised. And so just know that if your acts are deemed to be invalid as a result of an Open Meetings Act, it could have consequences beyond just having to redo it. And the second thing is that there are punishments, individual punishments available under the Open Meetings Act. And the Attorney General or the district attorney, or even private complainants, can bring actions under the Open Meetings Act for violations of the Open Meetings Act. And that can result in a punishment of $500 against every individual that participated, and every time it happens is a separate offense. So these aren't punishments or offenses to take lightly, because there's been several occasions where public bodies have been taken to task and held liable and accountable under the Open Meetings Act, and where members have actually had to pay these fines. And so it's something that has to be taken seriously. That's about all the time I have, I'm afraid. I really am. Wish I could have devoted more time, but I'm certainly willing to come back at any time and discuss these items or other items for you.
Thank you very much, Randy. We appreciate the information. And I'm sure that any of the counselors understand that when they think of any issue or question that they want clarified, they should and are very welcome to contact you, and you will try to help them with the answer.
And what I can do, if you want, Mayor, I will be happy to send this slideshow on over the Village Hall, and you can make it available, to the council and to the public,
Sure.
for that matter, if you want.
Yeah, that would be great. I think it's important for the public to understand, what we're trying to achieve here. So thanks a lot, Randy.
I've probably got a couple minutes if there's any questions. I want to make sure the council doesn't leave with unanswered questions, and if there's a lot, we'll have to maybe do this later, but if there's one or two, I'll be happy to take them.
Okay,
Mayor, this is
Councilor Murray. Yeah,
Yeah,
sure,
thank
go
you,
ahead.
Mayor, councilors, and Mr. Van Vleck, thank you. So you mentioned the attorney-client privilege as in the closed meetings, but is the attorney-client privilege extend individually in communications between, say, a counselor and the attorney?
Not specifically, no, sir. The attorneys, our client is the entity. So, I mean, while if it pertains, if you're talking about village business and how the village should be responding, that's one thing, and that comes a little bit closer to being protected type of speech. But I guess what I'm trying to say is this: if you have a little pet, let's say, for example, you had a pet project and you didn't want the rest of the council to know about it until a council meeting, and you wanted to make sure it was fully developed in your own mind, and you wanted to do things to make sure it was a well thought out procedure, and you shared that with me, I could not guarantee confidentiality, because you as an individual counselor are not my client. You're part of a larger entity called the Village of Corrales, which is my client. And I know that's sometimes kind of difficult to sort out, but I guess you just have to kind of think about it in terms of our first allegiance as attorneys is to the corporate entity.
But technically, I mean, you do work for us, is that correct?
Well, I work for the village. I don't work
Yes.
I don't work for the mayor. I don't work for the administrator. I don't work for any individual counselor. I work for all of you collectively.
Okay. Also, last council session, we had an issue where we're kind of going into a hybrid type of environment where we're in person, but we're also doing Zoom. And one of the issues is the public trying to use Zoom cannot get in to voice their opinion because there are technical issues. Can they use a chat or a hand raise to write their question and have it read into the record by the, the clerk?
Yeah, these are all new things that we're dealing with. And let me put it this way, there's certainly nothing wrong with that. Okay.
I have to
I don't think there's anything wrong with allowing chat because these meetings are recorded. People can look at those. It's not, and with all due respect to our guests there, it's not a fatal error if they can't get in. Because unless it's an actual public hearing, like on a zoning matter or something of that nature, public participation is not guaranteed by the Open Meetings Act. It's simply, it's guaranteed only by the whether or not the entity grants that right. And
Well,
so
that's a question I had too, because being a public, this is listed as a public meeting here.
Okay.
Even though it's a meeting for you guys to whatever, it's listed as a public meeting that the public is encouraged to view and be at, but the public is being denied any speak in a public meeting.
well, again, I'm not gonna engage in an argument at this stage. Just rest assured that the Open Meetings Act does not guarantee public participation. That participation, sir, is given to you by the village and by the village alone.
Well, please join us in the
Thank
next
you.
meeting for the
Yeah.
Colorado's Forum, please.
Yeah,
Thank you.
You might go ahead, Mayor.
Randy, we have to kind of roll into our regular council meeting in a couple minutes, and
Yep.
I did want to give our counselors a chance to stand up and then come and sit back down, and we need to get to a new Zoom. So again, I want to thank you very much for the information.
Thank you, Mayor. Thank you for having me, and
Okay.
we'll see you in some other capacity, some other time.
Okay,
Yeah.
bye. Thank you.
Thank you.
See you all in a few here.
Okay.